Hi, it's Musharraf Hussain with the subject of interpreting tax and statutes. Our today's topic is Act of Legislature. Act. Act denotes enactments that carry legislative effect. An act may be considered as a series of declarations of the legislature enforcing certain rules of conduct or conferring certain rights upon or withholding them from certain persons or class of persons. The separate declarations of the legislature contained in an act will be called enactments. These declarations are arranged in sections and schedules, if any, and such provisions are referred to as enactments of an act in General Clause Act 1819 7, Section 3, Clause 19. An act is distinguished from bill as the latter is the draft proposal which is debated by the legislative body. Legislative body means parliament or the legislature of the state in order to make an act. Provisions of a legislative bill referred to as clauses. Once it becomes an act, it is referred to as section, but once it is a part of bill, it is referred to as clauses. Does not have any legislative effect. Act of Parliament. An Act of Parliament is a law made by the President in Parliament, that is, a law that has been passed by both houses of Parliament or by the lower house or Lok Sabha alone in case of money bill and received the presidential assent. Act of the Legislative Assembly of the state. In case of a state, a law is made with the assent of the governor of that state once the bill has been passed by the Vidhan Sabha, the Legislative Assembly of that state. Where the Legislative Assembly of the state is bicameral, that is, it is having both lower and upper house as Vidhan Sabha and Vidhan Parishad, then except for the money bill, both the houses need to pass the bill before the assent of the governor is given to make it an act. So we see that in the formation of an act, three entities are mainly concerned. One, rather we can say that two entities. One is the executive head of the state in the form of president or the governor, and second is the legislative body. Legislative body may be the parliament in case of union law, and it may be the legislative assembly in case of a state law. Doctrine of parliamentary sovereignty. An act can lay down any proposition of law whatsoever. This parliamentary sovereignty can be read in the case of legislative assembly also. So the legislature of the state may also lay down any proposition of law whatsoever. This whatsoever is wider enough that an act may create any legal result. Parliament may lay down new law or change, abolish, codify any pre-existing law, statutory or not. There is no restraint on what an act can in theory do. Though practically, of course, it is not that much easy. As we can see that the doctrine of parliamentary sovereignty does not of course mean that parliament is free from conventional, political or practical constraints. One can see that It took around 17 years to make a single act of GST, the Goods and Service Tax Act 2017. The necessary corollary, the principle emanating from the doctrine of parliamentary sovereignty, is that Parliament can not bind, it cannot bind, either the Parliament or the Legislative Assembly cannot bind its successors. Means a later act will override an inconsistent earlier act. So, if the previous Parliament or the Legislative Assembly has made something which the current Parliament or the Legislative Assembly wants to annul, want to cancel, or wants to override, there's no check on that. It can do. And even if it is not directly annulling or directly cancelling, but it was found later on that no, some of the provisions of the later act is inconsistent with any existing act, then it is the later act which will prevail, not the previous act. Restrictions on parliamentary sovereignty. Previously we saw that the legislative body is under conventional, political and practical constraints. In India, we are having a written constitution. So Indian legislative body, that is Parliament and Legislative Assemblies of a state, has to function within the constraints of that constitution. Because it is the constitution from which the legislative power emanates. The legislative power, the power of the Parliament or the Legislative Assembly, comes from constitution only. Constitution has provided certain restrictions. First of all, regarding the subjects on which Parliament or the Legislative Assembly can legislate. And a law made beyond the assigned subject is bad, as provided in Article 246. Schedule 7 is there, on which different subjects have been enumerated, and of course we will see that there are three lists, list 1 and list 2 and list 3, with list 1 being the union list, list 2 being the state list, and list 3 being the concurrent list, where both union and state can make the law. So that list contains the different topics, the subjects on which the legislative body can make law. And if it is found that the law made by the legislative body is beyond the assigned subject, then of course it will be bad in law. Then there are fundamental rights guaranteed to the people of India, and a law made in contravention thereof is unconstitutional, as provided in Article 13(2). We can find a list of fundamental rights enumerated in Part 3 of the Constitution. Then again, provisions guaranteeing freedom of trade and commerce, enumerated in Article 301 to 307, also impose some restrictions on the parliamentary legislative power besides other restrictions. Validity of an act. The courts will not examine irregularities in connection with the introduction of a bill or its passage through Parliament or the motives of its promoter or legislator. Suppose anyone questions about whether this act is valid or not, then the court will not come and see that it has been irregularly passed or some practical lapses were there in passing of the act. And moreover, it will never look into the motive of the promoter because it cannot scan the wisdom of the legislature. The court is not empowered enough to ask the legislator that why you legislated this. This was mentioned in Commissioner of Sales Tax versus Mangal Sen, 1975, Volume 4, SCC, page 35. The only ground for challenging the validity of Act is that it is unconstitutional. Any law not conforming to the provisions of the Constitution may be declared ultra vires, that is beyond the competence of the legislature by the court, and such law may be struck off. If it is an act, then those provisions which do not pass the test of constitutionality may be struck off, provided the remaining provisions are not affected by it. So, an act, as we have seen that there are several legal declarations. So, if 4 or 5 sections or 4 or 5 or any one section is found violating the restrictions of Constitution, and if by striking it off it does not affect other provisions, then of course the entire act will stand, but that provision which is which does not pass the test of constitutionality will be struck off. And when it is found that no, the entire act is to be annulled, to be cancelled, as it doesn't pass the test of constitutionality, then of course the entire act will be declared ultra vires. A speaking act. An act of parliament should be deemed to be always speaking, and therefore the present or past tense should be adopted. If shall is used, then it is used as an imperative only. It is not that shall and will of future tense is used here. If it says that the state shall do or the person shall do like that, then the shall is being used as an imperative that he must do it. It is not used as a future tense. Even sometime if he is used, the word if he is used, then it should be followed by the indicative where it suggests a case. It should not be used like that. If I were a king, I would have done like that and that. That is not the language of act. Judicial notice of an act. Evidence Act 1872 says that the court shall take judicial notice of all laws in force in the territory of India in its section 57 clause 1. Laws here includes act of legislature, delegated legislations, and authorized law reports. Law reports where the judgments are reported, judgments of the courts like High Court, where we can find the precedents, judicial precedents. Judicial notice we will focus upon. A fact is said to be proved in the process of evidence, in the terms of Evidence Act. A fact is said to be proved when, after considering the matter before it, the court believes it to exist. So it is the court belief that something has happened or not happened. And in case of facts of which judicial notice is taken, the judge's belief in their existence is induced by the general knowledge acquired otherwise than in the proceeding at hand. So no fact of which court takes judicial notice need be proved. For example, the court can take judicial notice of the fact that many of industrial workers are illiterate, or the fact that rental has escalated everywhere. Thank you.